Yes.
May I please, Your Lordship? I am the plaintiff on behalf of item number 2. Due to the death of Mr. R.L. Yadav, Mrs. K. Yadav has gone to Allahabad due to ritual program. So kindly adjourn the matter. And item number 5 also.
Item 2 and item 5. In item 2, you say both sides are represented. It's submitted that as the learned counsel holding the brief has expired, matter be adjourned today. Prayer is allowed. Matter stands adjourned today. List after
4 weeks or after vacation.
No, you'll have to take steps for what you call. Because this 2009 matter, we'll keep it after 2 weeks. Make a. This is. I got application for Item 5, the both sides are, sorry, they submitted that the petitioning person whose has expired and therefore on the period made by learned counsel to the petitioner, the matter stands adjourned today. List on, you did give it take up 3 weeks. List on so and so. In the meanwhile, the needful be done on behalf of the petitioner.
Item 2, 4 of June. Item 5, 11 of June.
Item 5, 4.
Item 1.
Item 1 for orders.
May please, Your Lordship. My Lord, this appeal has been right today. As because the trial court judgment records has not yet been received as per the office note. And the motion court record has not yet been received.
No, that is not required because we in the first appellate order, first appellate record, that document is very much available.
No, they said that is the appellate court record is there in the in our record.
There is nothing more which is required.
My Lord, both the court records are
Why you tell us why it is required in the first place? We are dealing with second appeal.
taken.
The order of the trial court is required. We don't find anything here by which we have disputed anything in the exhibited documents. The question of law, this is a very old 2009 matter,
Yes, my Lord.
and the substantive question of law on which this was submitted for hearing
Well, let it be.
is whether the lower appellate court erroneously dismissed title appeal without following the mandatory provision laid down under Order 41 Rule 31, and whether the suit is liable to be dismissed for non-compliance of mandatory provision of Section 80.
Yes,
There are the two questions only.
yes. The trial court judgment decree was modified, set aside, and the appellate court has modified that decree by imposing the permanent injunction upon this appellants not to construct the path over to the graveyard. That is the, and the graveyard is situated on a government land. Government has not paid for injunction. Therefore, my only question before your lordship, issue before your lordship for decision is that whether the permanent injunction is can be
Mr. Judge,
issued,
what we
can
find
be
is
issued.
that the you are the plaintiffs.
And no, we are the dependent,
You are the respondents defendants.
respondent dependent, respondents are already, respondent hereof are the plaintiffs in the original suit.
Jacob, you are the plaintiff.
My lord?
You are the plaintiff.
No, no. We are the defendant in the original suit. We have filed, preferred the title appeal number 2 of 2005. Wherein the learned appellate court has dismissed or set aside the judgment and decree of the trial court and modified the decree by imposing
Okay.
permanent.
I was reading it wrongly because in the order, this Jacob is shown as plaintiff, respondent plaintiff. That is why there's this mistaken understanding who is the plaintiff.
No, no, we are the.
In the order of the, in the final order of the, this appellate order, Jacob is referred to as plaintiff. That's why.
Not,
Now,
the matter may be fit for hearing.
we are hearing it.
Hmm.
2009 matter, we are not adjourning.
No, no, I am not paying for any. Let me. Does not take more than. Let's put figure down. Government land fully laptop into into no, yeah, better people. So doctor no go.
The lawyer in this appeal for the appellant has to be a very good lawyer.
Well,
He's from which place?
from
Karimganj.
Karimganj. The appellate court has declared that the Switzerland is a public graveyard. And a public graveyard, and we have been permanently restrained from.
From creating a path.
Yes, my lord. There is our claim is that there is an existing path over the graveyard, for the graveyard. But
It's not been proved.
but the appellate court has
But
disagreed with that.
there's no proof of that.
Yeah.
How did you prove it? That there is a path.
We failed to prove it. The courts below has decided that there is a graveyard.
No, you
Right.
see, first is that in the plaint,
My lord.
what is your prayer?
Not our prayer, their prayer. Respondent. Respondents were the plaintiff.
Respondent plaintiff, yes. What is the prayer?
My lord.
To maintain status quo of the land. Have it graveyard and community place establishment of the right and so and so. To establish as per any provision.
For declaration that the scheduled
declaration of
supply
correction record of-
comprising plot number 1 and 2 as their private graveyard. They have claimed, they have paid for declaration.
Mr. T.K. Pataki, none is transferred to the petitioner, none appears on. Mr. T.K. Pataki, none is transferred to the petitioner, none appears on part of the respondent. Next one. So the records were called for by order dated 5/8/2009. Your appeal will again be dismissed for non-prosecution.
My lord. Aya nomor kemana? Aya nomor kemana? Saja sir. Hmm? Ah, ah, ah. Order date 1912. Yes, your lordship may mirror the
You see,
order.
your appeal was dismissed for non-prosecution
Yes, my
because
lord.
steps on respondent 5 was not taken.
No, I haven't, I could not gather the required information
But till
regarding
date,
him.
you have not taken
Therefore,
steps. Although on your prayer, the matter was restored,
restored.
but you still did not take steps for service of notice on
But-
respondent number 5.
We have failed to gather the required information
Then,
regarding. Therefore, we have no claim against the respondent number 5 that she may be related. Strike off.
Respondent number 5 is the plaintiff.
Yes, madam.
So even you have no case against the plaintiff.
No, in view of the appellate court judgment, we have no claim against her.
In the first appellate decree,
First,
in the first appellate decree,
yes, my lord.
you were restrained.
We have been restrained to construct any part of our graveyard.
And the beneficiary
Yeah.
of that order
Yes,
is also
your
defendant number, respondent number 5. The decree is inseparable.
Yes,
The appeal will abate then. It will not be dismissed, but it will be abated. Abate is as good as dismissed.
my lord, kindly allow our some time to
No, but you see,
substitute
the
the
order to take steps was passed when? The order to take steps
but I could,
was
we could not
passed
gather the
in
required
25/11,
information.
2019.
The, we could not gather the required information about the heirs of the response number 5. So we could not take the steps
The
in
question
the
of
appeal.
here will not come. Whether he's dead or not, you have not even stated he is dead or not.
Disbursement, मागे म्हणाल एकत्र आहे गंडगोळ लुटपून असताना की
Okay, let me check. This court by order dated 25/11/2019 directed the appellants to take steps for service of notice on response number 5. Steps was not taken, and therefore by order dated 25/7/2022, this court had observed that if no steps are taken and the appellants are not represented, court would have no option but to dismiss the appeal. But the matter was thereafter listed on 24/8/2022, and due to absence of the learned counsel for the petitioner, appellant, the appeal was dismissed. Thereafter, the appeal was restored by order dated 19/12/2022, passed in MC 13 of 2022. Was restored, public readmitted to be created. Just notice that notice from the record of MC 13 of 2022 that where the said appeal, when this appeal was restored by order dated 19/12/2022, no notice was issued on the respondents. And it also appears that none appeared on call for the respondents upon whom notices were already served. It may be stated that when the appeal was when this appeal was dismissed for non-prosecution, the counsel, learned counsel for respondent numbers 1, 3, 4, and 8 to 26 within bracket A were present. Therefore, readmission of the appeal as the direct counsel for respondent numbers 1, 3, 4, 8, and 8 to 26A were represented, and presence is recorded in the order dated 22/4/2024. The court is inclined to direct the appellant to take test steps for service of notice on respondent numbers 2, 5, 6, 7, 26, 24, within bracket I, 1, Roman bar, I, small, to 24, 7, 8, 26, B, 26C, and former respondents 27 to 30 is served again. The appellant shall take steps within a week from the date of this order to serve notice on the aforesaid remaining respondent by speed post with AD. The Grand Counsel for the appellant shall also serve requisite extra copies of the memo of appeal to the government advocate who would accept notice on behalf of respondent numbers 31 to 34. And a proof of service of extra copies be filed prior to the next date of listing. Next, the Grand Counsel for the appellant is at liberty to collect the postal receipt numbers from the registry and to submit postal track report prior to the next date of listing. Next paragraph. Appellants are put to notice that as this appeal is of the year 2009 and filed on 16/2/2009, on failure of the appellants to take steps to invite dismissal of the appeal for non-prosecution. Next paragraph. In the meantime, the registry has also issued a fresh requisition for the records of title suit number 170 of 1989. We called from the Court of Civil Judge within bracket Union Division, Karimganj. The request to the said learned court to expeditiously send the request to send the records this court as early as possible. Accordingly, the office of the civil judge within bracket Union Division, Karimganj, has bring the order to the notes of the said learned court. It is the that send the requisition to email address of the learned civil judge within bracket Union Division, Karimganj, along with a copy of this order. Next. We said notice to it once, notice is made returnable on, give a date after 5 weeks. Return of consequence. Next. List on transfer. List on transfer. If you let the parties are put to notice that at the next date of listing, the matter should be taken up for hearing. List on transfer. List on hearing if the records are received. The service is complete. On the next date, you are getting 7 days time to take steps on all those respondents who are not represented by Mr. Sinha.
My lord.
Steps within a week,
Obliged.
telling which the matter would be dismissed for non-prosecution.
Obliged, my lord.
And on the next date of listing, if the service is complete and the records are received, at whatever stage it is listed, it will be taken up for hearing.
My lord. My lord.
This item 3 and 4. Yes.
My lord, these two appeals are interrelated because the appellant herein was the defendant counterclaimant. And plaintiff filed a suit for declaration that the agreement which was signed between the plaintiff, deceased plaintiff and the deceased defendant was declaring plaintiff decree declaring that plaintiff has existing right title and continuous possession.
In this case, who is in the trial court, who is the plaintiff?
Plaintiff is the deceased respondent herein, Muzammel Haq.
Muzammil Haq.
Muzammel Haq. Deceased. And defendant is the Jitendra Mohan Saha and Meena Rani Saha. Meena Rani Saha is the wife of Jitendra Mohan Saha. Now Jitendra Mohan Saha is also deceased.
Yes, and this Sadiq Hussain and all, they are pro forma defendants.
They are pro forma defendants. Because they are pro forma defendants on the ground that the land on the basis of which the present appellant claiming performance of the contract, their land was the joint land, and pro forma defendant said that there was a partition. So the registered agreement was in between the plaintiff and the defendant are separate land. Suit was initially dismissed, my lord, and the counterclaim filed by the defendant was also dismissed. Then appeal has been to appeal.
Yes.
Then two appeal has been preferred, one by the plaintiff, one by the defendant. And the appeal filed by the plaintiff was decreed, and the appeal filed by the defendant was dismissed. So there are two second appeals. One is against for decree of the suit, another is against dismissal of the counterclaim.
It was dismissed, you said.
Yes, trial court suit was dismissed and counterclaim was also dismissed.
Yes.
Then we prepare appeal, two appeal, one by the plaintiff, one by the defendant. So in the appeal filed by the plaintiff was decreed, and the counterclaim against counterclaim appeal filed by the defendant was dismissed. So two appeals filed by, one is against decree, one is against for dismissal of counterclaim. Basically, my lord, the substantial question of law were framed, kindly see 15/2/2010 order. In 16, RSA 16 of 2010, whether learned lower appellate court committed error in holding that the suit of the plaintiff is not barred by limitation, while reversing decision of the learned trial court on this issue. Number two, whether the suit of the plaintiff is barred under proviso of section 34 of the Specific Relief Act. Number three, whether on the part of the whether on the fact of the evidence on record, the learned lower appellate court erred in law in declaring title of the plaintiff over the suit land. And in RSA 17, whether the learned court below erred in law in holding that the counterclaim of the appellant is barred by limitation. Number two, whether the learned court below erred in law in not taking into consideration regarding evidence regarding full payment of consideration of to the plaintiff, handing over possession following by the disposition. Fact, my lord, nutshell facts is that, my lord, initially in 89 there was an agreement between the plaintiff and the defendant, and on the basis of that agreement, my lord, the defendant paid 10,000 rupees to the plaintiff as an advance money, my lord. And subsequently, my lord, after receipt of remaining 13,000, that is total consideration was 23,000. After being receipt of remaining balance amount, without executing sale deed, possession of the land has been handed over to me. Then
Possession of land is not handed over to you.
possession was
Because
handed over.
in the proceedings before the executive magistrate,
Yes,
the position were declared in the favor of the defendants.
no, that evidence will come, possession was handed over initially. Subsequently, they have dispossessed. That is there, my lord. Possession handed over, it will come, my lord, in the evidence that yes, possession has been handed over, and consequent to that possession also, mutation has been granted in favor of the defendant also. Mutation was also there, my lord.
How did the mutation happen without sale deed?
Yes, without that part is there, mutation was there, and possession was handed over, and it has from the reply from the pro forma defendant also, who are the co-sharer, they also said that yes, initially 10,000 rupees was taken, then after receipt of the remaining balance amount, possession has been handed over, but in the year 1991, I shifted to another place. In 89, possession was given. This is the nutshell in this case, my lord. And regarding balance amount, I have proved that the entire amount, consideration amount has been paid. Now kindly see the plaint, my lord. May I read, my lord?
The agreement is of 1989.
89.
What is the date?
Agreement date is
5689.
agreement date is 5/6/1989.
So by what time, when as per the law, you can come for specific performance of contract?
That is, if from the refusal of the performance, 3 years, my lord. Limitation Act. My lord, one thing, my lord. Possession in the magistrate court, possession was declared in favor of me. The lower court, after hearing the parties, disposed of the proceeding on 13/10/1997, declaring the possession of defendant number 1. But it was stayed by divisional court in choice.
Yes.
My lord, kindly see the plaint at page 5, my lord.
We've seen that.
Plaint, another, and in the counterclaim is page, written statement come counterclaim, page 10, my lord. In page 10. Paragraph 12, kindly see. Page 11.
Yes, paragraph.
12. Regarding possession part, my lord. Lordship got it. In 2/9/1998, the possession was handed over by the police also. And now straightway I can go to the, my lord, the judgment of the Planet Trial Court, my lord. Page 23.
Page number
26.
26.
23. May I read?
Just a second. I think something. Yes, page number 23.
23. From 24, I may. This is the suit for declaration of right title interest of the plaintiff and for confirmation of possession over the suit land, specifically described in Schedule B to the plain and for permanent injunction, etc. The case of the plaintiff in a nutshell is that he is the owner of the suit land by amicable partition with his co-sharer in Schedule A paternal property. In the middle part of 1989, there was an agreement between the plaintiff and defendant number 1. The agreement was admitted, my lord. For sale of the suit land at a consideration amount of rupees 23,000 only, and the sale deed was to be executed after the payment of consideration amount within 3 months from the date of
Those are
agreement.
the averments. You can come directly to the issues discussed at page 28. So those are parts of pleading.
Pleadings, yes. Then issue 27, my lord. What is there any cause of action for the suit? Is the suit barred by limitation? Is the suit barred by res judicata? Is the suit is hit under section 34 of specific relief act and under order 2 rule 2 CPC? Whether the plaintiff has right title and possession over rescheduled land, whether the defendant are re-entitled to get registration of sale deed for the suit land from the plaintiff, whether the plaintiff is entitled to get decree as paid for, whether the defendants are entitled to get decree as paid for in the counterclaim. Now, straightway, my lord, the issue number 4. This is the suit for declaration of right title interest, confirmation of possession of the plaintiff in respect of Schedule B land, along with the permanent injunction against the principal defendant. Rule 2, Order 2, read with so-and-so, every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but the plaintiff may relinquish any portion of the claim in order to bring the suit within the jurisdiction of any court. Learned advocate so-and-so, appearing for the defendant, submitted that plaintiff has not sought for cancellation of the agreement which is entered into with the contesting defendant in 1989. As such, the suit is not maintainable. Considering this averment, the plaint and the relief prayed for by the plaintiff, I am considered opinion that in absence of prayer for cancellation of agreement, suit is maintainable so far as declaration of right title interest of the plaintiff over Schedule B land is concerned. Moreover, there is nothing in evidence to hold that suit is not maintainable. And both the court below concurrently held that suit is maintainable. But here in this case, the questions of law also frame that proviso of section 34 of the Specific Relief Act has not been considered. Because in absence of the cancellation of that agreement, my lord, whether suit can be maintained or not. And apart from that, they have not also prayed for cancellation of the agreement, more so when they have admitted that there was an agreement was signed between the parties, and they have accepted earnest money of rupees 10,000. And regarding subsequent part, my lord, that I will come later on. But here, for the purpose of the maintainability, this much is my submission that under section 34, proviso to 34 of the Specific Relief Act has not been considered. Now, issue number 5. In the discussion of this issue, it is very vital to see whether right title interest of the plaintiff extinguished on his execution of deed of agreement for sale of Schedule B land by the plaintiff in favor of defendant number 1. The admitted and undisputed fact between the parties is that plaintiff, being the owner of Schedule B land, executed an agreement in 1989 for sale of the same in favor of the defendant number 1 at consideration price of rupees so-and-so, only out of which plaintiff received rupees 10,000 as an advance amount at the time of execution. Exhibit 1 is an agreement dated 5/6/89 executed by the plaintiff in favor of defendant number 1 with respect to Schedule B land. Plaintiff Mozammel Haq, in his cross-examination, has admitted the signature of Exhibit 1, A1, to be his own. So, regarding agreement, it is admitted position, my lord. Exhibit A clearly indicates that agreement between the plaintiff and defendant number 1 was executed on 5/6/1989, and the plaintiff received rupees 10,000 as an advance amount on from the defendant number 1 for sale of Schedule B land at a price of rupees so and so. Exhibit A is totally silent whether on receipt of the said advance amount on 5/6/89 and having executed Exhibit A, the plaintiff delivered possession of the said land in favor of defendant number 1. According to the plaintiff, even if the agreement for sale of the said land was executed on receiving advance amount so and so, but defendant number 1 was never handed over possession thereon. On the other hand, contention of the contesting defendant is that plaintiff, having received the total sale price, delivered possession of the Schedule B land to the defendant. Another undisputed fact between the contesting parties is that the instance of the principal defendant proceeding under section 145 CRPC was started against the plaintiff in respect of Schedule B land. Exhibit E, order dated so and so, passed in connection with the said case number so and so. The learned executive magistrate Hatsingmari clear reveals that second party plaintiff constructed a set out over the disputed land and first party kept stand, brick, etc. for construction of the house thereon. Thus, Exhibit E indicates that the defendant number 1 first party was not in clear possession of the said land. Exhibit G, certified copy passed in so and so, indicates that executive magistrate declared possession of disputed suit land in favor of first party defendant, and police was asked to hand over possession to the disputed land in favor of first party. Exhibit I. One is the police report connecting I. Exhibit G is order. Exhibit I revealed that on 2nd September 1998, police only delivered symbolic possession of the disputed land, Schedule B land, in favor of the first party, the defendant. Because the police found that second party Muzammel Haq at that time was already possessing this same by constructing a house and residing with his family over the disputed land. Para 14C of the counterclaim clearly and palpably show that defendants have practically no possession over the Schedule B land for which they have prayed for recovery of first possession by removing the house of the plaintiff. Admitted position between the parties is that no sale deed was executed and registered in respect of Schedule B land in favor of defendant number 1 and 2 by the plaintiff. Hence, right, title, interest, and possession of the said land remains with the plaintiff. Even if argument checks, it is accepted that plaintiff accepted the entire consideration amount, then also right and interest of the plaintiff in respect of the said land cannot be transferred in favor of the defendant without a registered sale deed, which is sine qua non under section 17 of the Registration Act. More so, when Exhibit A is an unregistered document, the defendants are not in actual physical possession of Schedule B land. In the light of the above discussion reason, I find to hold that plaintiff has right, title, interest. Plaintiff has right, title, interest, and possession over the suit land. This issue is answered in affirmative. In view of the findings arrived at issue number 5 and taking into consideration materials averment in the pleading of the parties, I find there is cause of action for the suit. The suit is according next to this is the suit for declaration of right, title, interest, and for confirmation of possession of plaintiff over Schedule B land along with the consequential relief. Issue number 2 have already answered in affirmative cause of action of the suit. Suit passed on 3/12/1992, which has been specifically awarded in para 9 of the plain and which has been referenced to para 5 of the plain. Article 58 of the limitation has required that declaratory suit is required to be filed within 3 years from the date when the right to sue first accrues. In the instant case, plaintiff's right to sue first accrues in the date of the first cause of action on 3/12/1992, but the suit was filed on 15/5/1998. That being the so, suit barred by limitation. On this ground, the suit was actually dismissed, that it was barred by limitation. Regarding counterclaim, the counterclaim of the defendant number 1 and 2 is for specific performance of contract against the plaintiff as per agreement made by the plaintiff for sale of Schedule B land at consideration amount of rupees so and so, only out of which plaintiff admittedly accepted rupees 10,000 as advance on the day of execution of the agreement. Now the most important point is look into the terms, condition and stipulated as the agreement made by the plaintiff in favor of the counterclaim. Exhibit A is an agreement executed on 5/6/89 by the plaintiff in favor of defendant number 1 and 2, wherein time within which the plaintiff is required to execute the sale deed in favor of the defendant number 1 is not defined. There was no time stipulation. Therefore, as per Article 54 of the Limitation Act, counterclaim for specific performance of contract by the Exhibit A was required to be instituted from the notice of refusal to perform by the plaintiff. Now, the moot question is as to when the defendant could come to know about the refusal of the plaintiff for specific performance of contract. Learned counsel, Mr. So-and-so, appearing for the counterclaimant, strenuously argued that the defendant number 1 and 2 could come to know about the refusal to perform the part of the contract by the plaintiff only after institution of the suit. But admittedly, the counterclaim number 1 and to file proceeding under section so and so when the plaintiff threatened to dispossess from the Schedule B land. That being so, the counterclaim number 1 and the implied knowledge that plaintiff was unwilling to perform his part of the contract, that is execution of registration of the sale deed in favor of them, hence the submission of the learned counsel for the defendant cannot be accepted. In the last part of 1992 or 1993, the counterclaim ought to have been filed to say suit for a specific performance of contract, but the counterclaim was filed only on 1/2/1999. Therefore, from the above discussion, it is perfectly clear that counterclaim is barred by limitation. Accordingly, issues answered in favor of affirmative and against the counterclaimant. It has been held discussion of issue number 9 that the counterclaim is barred by limitation, speaking in other words, by explux of time, the agreement by the Exhibit A lost its legal force. Hence, plaintiff cannot be held legally bound by the contract of Exhibit A. This finding is not correct. In so far as counterclaim is concerned, my lord, immediately after filing of the suit, I came to know that they are not performing, so I filed this suit counterclaim within time. Accordingly, this trial court dismissed the suit and counterclaim, both on the count of limitation. Now, appellate court, my lord, what appellate court did, my lord, page 40. You can skip, my lord, page 40. Straightway decision and additional issue number 18, page 44. 2 additional issues were also framed. Whether the counterclaim of the defendant is maintainable, whether the counterclaim of the defendant is barred by limitation. Decision and reason. Mr. So-and-so, senior counsel for the plaintiff appellant in title appeal number so-and-so has submitted that learned trial court erred in law in deciding the issue number 2 against the plaintiff, since the provisions of Article 50 of limitation is not at all applicable in the factual situation of the instant suit. He has argued at length that Article 56, 57, 58 of the Limitation Act are only applicable to the suit for declaration without any consequential relief, but the present suit was instituted by the plaintiff for declaration and injunction. As such, suit comes under Article 113 of the Limitation Act and not under Article 58 of the Act. The learned trial court applied Article 58 of the Limitation Act in deciding the issue number 2. The issue number 2 relates to whether the suit is barred by limitation. The Article 58 of the Limitation Act says that to obtain any other declaration, the period of limitation is 3 years when the right to sue first accrues. But the present suit was instituted by the plaintiff for declaration for right title interest, for right title and possession as well as for permanent injunction. And in this case, the such suit, there is no prescribed period of limitation. Therefore, Article 113 of the limitation is applicable since the suit is for declaration and consequential relief. As such, the period of limitation is 3 years when the right to sue accrues. The word right to sue means right to seek relief by the plaintiff when his right has been infringed by the defendant. In the instant suit, the admitted position is that plaintiff is the owner of the suit property and there was an agreement to sell the property to the defendant number 1, and further plea of the plaintiff is that he never delivered the possession, but defendant mutated his wife's name, and on being objected, the mutation was cancelled. Thereafter, the defendant clouded his right, title, and possession over the property by instituting various criminal proceedings, even as filed the counterclaim. Therefore, this bundle of facts are the cause of action, and the plaintiff is his liberty to file the suit within 3 years of such cause of action. The defendant number 1, DW1, in paragraph 6 in his evidence in affidavit has stated that there was a criminal revision so-and-so against the order of the learned executive magistrate passed in Miss Case number so-and-so on 13/10/1997, possession of the suit land as declared in favor of the defendant and directed the police to give possession to the defendant number 1. And as per direction of the additional session judge, learned lower court handed over possession of the suit land to the defendant through police on 2/9/1998. Thus, it is clear enough that right of the plaintiff had been clouded, rather jeopardized till 2/9/1998, and the present suit was filed in 1998. Therefore, the suit is apparently within period of limitation. Therefore, the dismissal of the suit of the plaintiff is bad in law. The admitted position is that plaintiff entered into an agreement to sell the suit land to the defendant number 1, and Exhibit 1 is said agreement. As such, there is no conflict between the parties as to ownership and title of the plaintiff over the suit land. Therefore, defendant number 1 in his evidence in affidavit has asserted that plaintiff in the month of November 89 delivered the possession to him. And during cross-examination, he has given the boundaries of the suit land as follows, so and so. His further version is that at the time of disposition, time of deposition, the suit land was not in his possession, and there are houses belonging to the plaintiff resides in the distance of 3 kilometers away from the suit land. But in the counterclaim, defendant number 1 described the boundary of the suit land as follows. Thus, there is an apparent variation of boundary with the counterclaim and the oral deposition of defendant. Thereby, it is clearly shows that defendant has failed to support his counterclaim. Therefore, the above variations clearly shows that defendant number 1 was never in possession of the suit land, since he could not give the description of boundaries of the suit land telling the counterclaim. That apart, although the defendant number 1 in paragraph number 6 of his evidence in affidavit has deposed that the police delivered possession of the suit land to him on 2/9/98, but the alleged delivery of possession by the police perhaps was symbolic only, since in cross-examination he has asserted that suit land is not in his possession. The above evidence, it is clear enough to hold that plaintiff has possessing the suit land. Thus, the decision of the learned trial court in issue number 5, holding that the plaintiff has right, title, interest, and possession over the suit land, is found to be in conformity with the evidence on record. The learned counsel of the defendant so-and-so has submitted that plaintiff did not seek any relief or declaration challenging the lease agreement sale exhibit A. Therefore, suit is barred under section 34 of the specific relief act. Since the said agreement so-and-so has not been challenged by the plaintiff himself, as such, said agreement remain in force, and referring the decision of so-and-so, reported in so-and-so, submitted that plaintiff filed the suit for declaration only, but failed to seek further relief against the agreement for sale, being able to seek further relief than mere declaration of title, but omits to do so. In that case, courts shall not make such declaration, since the suit is not maintainable under section so-and-so. But plaintiff has claimed that agreement was rescinded as the defendant had failed to make the payment of balance amount. That apart, the suit of the plaintiff was not only for declaration of title, but it also includes declaration of possession, as well as for declaration that the finding of in criminal case number so-and-so is erroneous, and also includes for perpetual injunction. So the suit is not mere naked declaration. Therefore, suit cannot be said to be hit under section 34 of the specific relief act. The word further relief embodied in section 34 of the specific relief act means the relief or reliefs apparently inherent in the original claim of the suit. Thus, in the context of the present suit in hand, the aforesaid decision do not help the defendant. The suit was instituted by the plaintiff for declaration of right title and possession, as well as for injunction in respect of the suit property. Thus, the suit includes whole claim of the plaintiff. The exhibit A is an agreement for sale executed by the plaintiff, and the case of counterclaiming is based on exhibit A. Therefore, it acts and acknowledges the ownership and title of the plaintiff by the counterclaimant. Counterclaim DW1 has exhibited the said agreement for sale, which is marked as exhibit A, and as per version of the said agreement, sale deed was agreement for sale was executed on 5/6/98, and the defendant filed the counterclaim on 1/2/1999. The counterclaim was filed by the defendant for declaration for specific performance of the said agreement of sale, as well as possession and permanent injunction. In such case, Article 54, read with 113 of the Limitation Act are applicable, being proper provision. For specific performance of contract, 3 years period has been prescribed for filing a suit, but this 3 years period has to be counted in the mode indicated in the last column, which is in two parts. The first part indicates that in case any date has been fixed for the performance of contract, in that event 3 years period will be counted from that date. But where there is no date fixed, the second part would be applicable, which is substance is that the period of 3 years would commence to run when the notice of performance is refused by the plaintiff. In the said agreement, no specific date and time has been mentioned fixing for specific performance. Therefore, in our case in hand, 3 years would be commenced to run when the notice of performance is refused by the plaintiff. Our Honorable Supreme Court so-and-so held that in terms of Article 54 of the Limitation Act, suit for specific performance of contract is required to be filed within 3 years. In the event no date is fixed for performance within a period of 3 years from the date when the plaintiff has noticed that performance is refused. Admitted position is that defendant number 1 had instituted criminal proceeding number so-and-so. In paragraph 5 of his evidence in affidavit, he has deposed that plaintiff with bad intention raised dispute in November 1992 for the suit land. There was several sittings to compromise but failed. The defendant had filed so-and-so and attached the land. Magistrate made local investigation on so-and-so, recorded the evidence, decided case number so-and-so in favor of the deponent. The above assertion is clear enough that plaintiff refused to perform of the agreement in 1992-93, and counterclaim of the defendant came to about refusal of the plaintiff in the year 1992-93. But the counterclaim praying for declaration of registration of sale deed has been filed in 1999, which is apparently barred under section so-and-so. As such, the counterclaim in respect of the decree for registration of sale deed cannot be declared under the law, but Article 54 of the Limitation Act cannot apply for whole counterclaim. It deserves, as mentioned, that counterclaim of the defendant shall have the same effect as the cross suit, so as to enable the court to perform a final judgment in the same suit. Both the original claim and the counterclaim, that there is to say that the counterclaim of the defendant is cross suit, and counterclaim shall be treated as a claim and governed under this is regarding. Next page. As such, as stated herein above, the counterclaim also includes for permanent injunction. Thus, the entire counterclaim cannot be said to be barred under Article 54 of the Limitation Act, and in such case, I am of the opinion that suit also come within Article 113 of the Limitation Act, since the suit for injunction would be governed by a residuary Article 113 of the Limitation Act, and the cause of action for the said relief arises when the right to sue accrues. Plaintiff instituted the suit for declaration of his right, title, and possession on 15/5/1998. The suit of the plaintiff itself is challenged to allege possession of the defendant. Hence, the right to sue for the defendant in the strict sense accrued lastly on receipt of summons in the suit. The proposition of law is that if the person obtain a possession of the property in the part performance of agreement for sale, can defend his possession in a suit for recovery of possession filed by transferring so and so 53A of the TP Act, transfer property as shield. Even if suit counterclaim for specific performance of the agreement of sale has become barred by limitation, the suit filed on 15/5/1998 and the counterclaim for injunction, etc., filed by the defendant on so and so, therefore, counterclaim is within the period of limitation. Now it is held that counterclaim is within limitation. The counterclaim defendant number 1, in his cross-examination, so and so has admittedly asserted that at the present suit, land is not in my possession, therefore, prayer for permanent injunction cannot be claimed by the counterclaimant for lack of his possession over the suit property. Granting of an injunction is not a charity but discretionary, and as such discretionary and can be invoked to defeat the justice. The mere admission of an agreement for sale of the plaintiff does not mean or is an interference that plaintiff also admitted the delivery of possession of the property. Therefore, decision reported in so and so is not applicable, since agreement to sell exhibit A became a dead horse. So and so defendant, referring the decision of our High Court so and so has submitted that the fact of the criminal proceeding under section so and so is an admitted fact, and that criminal case possession was declared in favor of the defendant. So the verdict at the different stage of the said criminal case is cogent evidence of possession of the defendant. But regard to the said that any finding of evidence of possession in criminal court is not binding in civil court, therefore can not supersede the finding of the civil court. Civil court is to give its own independent finding on the basis of evidence on record. As discussed above, defendant counterclaim has failed to prove his possession. Rather, he has admitted the possession and control of the plaintiff over the suit land. Therefore, counterclaim of the defendant is liable to be dismissed. So basically, the trial.
Take a short break and come back.
Yes. Only two submission is there, my lord. Since the discretionary, the lower appellate court, while specific performance was rejected, the discretionary power has been invoked, saying that this agreement is stale, so discretion cannot, it cannot be enforced. That is sum and substance of the case, because it is clearly held that it is within time. Regarding time frame, there is no mention, but while the discretion has been exercised, my lord, the learned court below have not considered about the consideration amount, the advance amount, which admittedly prove that amount has been accepted. And so far with respect to the suit is concerned, my lord, though it is said that declaration of title is concerned, my lord, in the suit, but basically this suit is for cancellation of the agreement, which they have not prayed for. And why they have not prayed for? They have not prayed for on the ground that since the agreement was of 89, in the 1999, obviously suit would be barred if they would have been prayed for cancellation. And when there was an agreement between plaintiff and defendant, it is an admitted position that the plaintiff is the owner of the suit land. Now, when he has admitted that defendant admitted the ownership of the plaintiff, then question of declaration of right title interest come to the plaintiff when the same was clouded. Here, there was no cloud.
Please repeat again. You are saying that who has admitted ownership? Defendant has admitted
Defendant
ownership.
automatically, defendant admitted the ownership. That is why there was a contract. Defendant means counterclaimant. Admitted the ownership. They also admitted that they have the owner of the title. We have not disputed. Now, when this suit has been filed, plaintiff himself clouded his title. Otherwise, why he has filed this suit for declaration of right title interest? So my submission is that the suit for declaration of right title interest is not maintainable, as because the title is not clouded. Since title is not clouded, so question of declaration of right title interest is not maintainable. Now, rather, indirectly they have prayed that this agreement for sale is not binding upon them, but that prayer is not in the plain. And the learned lower appellate court, while discretionary power has been exercised, my lord, in respect to the counterclaimant, the discretion has not been, while the power has been exercised, it has not been considered about the what would about the consideration amount. And so far is remaining part, balance consideration amount, that is also an evidence that they have accepted the balance consideration. That has also not been discussed. So far 10,000 is concerned, it is admitted position. Remaining 13,000, that has also not been discussed in this present counterclaim. So in view of this, my lord, this judgment passed by the learned court below is liable to be interfered with by answering the substantial question of law in favor of the appellant. This is the true sum and substance of my.
Advance of 10,000 and balance of 13,100.
Yes.
Just a moment, your basic points of argument, I'll just recapitulate.
Yes.
First is, if the plaintiff does not pay for cancellation of agreement for sale, suit would be maintainable, would not be maintainable. You are referring to section 34 proviso.
Yes.
Second point is that the decision on issue number 6 was not correct.
Decision on issue number 6 is with respect to limited.
I forgot.
No, sorry. Get registration of sale deed, issue number 6.
Issue number 6.
Yes, it is regarding counterclaim.
This is the point you have raised.
And
This
another
is,
aspect, my
this
lord,
is just a moment.
yes.
Point number 3 you have said is, while the suit was within time, the discretion exercised not to grant relief was
Not
correct.
suit, counterclaim.
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 And nothing was considered in respect of the money already paid.
Yes.
Point number 4 is that if the defendant had not paid for cancellation,
Not defendant,
plaintiff has not paid for cancellation of agreement for sale, then the suit would not be maintainable.
My lord, another aspect, the suit which has been filed, kindly see the prior in suit, my lord.
Yes, noted that.
Yes. Suit which has been filed, my lord, basically for declaration of right title interest. When the title is clouded, then only suit for declaration is come.
That we are coming to.
Yes. Oh, yes.
Point number 5 is that when the defendant admitted ownership of the plaintiff and plaintiff has filed the suit, he has clouded his own title. And then you say that you have again repeated that the amount, there is an admission that amount advance of 10,000 is received and the balance payment of 13,100 is also.
Not admitted that I am, it was in evidence is there, that was not discussed by the both the courts.
Yes.
Please, Lordship. Lordship, regarding whether the suit is maintainable in absence of a declaration or cancellation of the alleged agreement for sale. Lordship, my suit is based on my right title interest, and for confirmation of my possession.
You are Mr. D. Kalita.
D. Kolkata. My appearing Mr. Deepik Hogan.
Yes.
My entire suit was based on right title interest and for confirmation of possession and for permanent interest. It has been admitted by them that he was not in possession in the suit land. So when my right title interest has been clouded, it has been elaborately mentioned also that in the year 1992, they have mutilated the land illegally. Therefore, they have preferred many criminal cases, one after one, one after one. And finally, when the learned additional district judge has passed an order to give delivery of the land to me, my entire right title interest is clouded. Therefore, I have filed a suit for declaration of my right title interest, for confirmation of my position, and for permanent interest. And regarding Lordship, the agreement for sale, they have alleged that that has been already in force. Lordship, may kindly peruse my plain Lordship.
Yes.
In para 2 of my plain, I have written that in the middle part of 1989, the defendant number 1, on payment of an advance of rupees 10,000, made an agreement for purchasing the share of the plaintiff at rupees 23,000 within the 3 months of the. It was agreed that within 3 months of the date of agreement, payment of entire amount has to be made by them. And by obtaining a registered sale deed of the purchase and taking possession of the land schedule bill, that even after repeated demand, as the defendant number 1 failed to make payment within the stipulated time and even within extended period, the agreement was resigned, and no sale deed was executed and non-possession was delivered. I have been mentioned in my plain, Lordship, why the agreement for sale has been already been cancelled, because in spite of repeated requests, Lordship, they have failed to perform their duty. And in that case, Lordship, whether it is required that a separate prayer for declaration of a cancellation of the alleged agreement for sale is required or not. Because my entire suit was based on my right title interest, Lordship. And they have been deliberately tried to dispose me from the suit land. And Lordship may kindly peruse their WS, Lordship. Detailed statement on or behalf of the defendant has. May I read it, Lordship?
You are reading where?
From their WS, Lordship. WS of a defendant.
Yes.
Also, may kindly peruse para 9, Lordship, the WS. That in reply to para 2 of the plain stated that there was a bainanama on 5/6/89 and the plaintiff received 10,000 in advance after total of rupees 23,000, but there was no condition for restitution within 3 months. Yet in reply to para 3 of the plain, that the answering defendant stated that the plaintiff received the balance amount and gave delivery position to the defendants for the suit land. The defendants got delivery position in the month of November 1889. Constructed facade house thereon, collected bricks, gravels, and for construction of the house of the suit land, and also ground banana tree, etc. in the suit land by the defendant. Lordship, may kindly peruse para 12, Lordship, that is important. That the plaintiff with ill motive to the misappropriate the money of the defendant and take back the possession of the suit them stated disturbance in peaceful possession of the defendant were compelled to file a missed case number so and so 1/19 against the plaintiff. There were several cases being missed case number 1/93, CR number 1 within bracket 497, which was finally decided in favor of the defendant. So they have lordship, why I have compelled to file the suit. So there are several proceedings going against me in the meantime. And I have filed the suit on 1998 lordship. So therefore, when cause of action accrues, as per Article 113 lordship, when cause of action accrues, because my right to the interest has been clouded. That's why I have filed the suit. In next paragraph, the police, as per order in CR number 11 within bracket 4 1997, gave delivery of possession to the defendants on 2/9/1998 with a note that a house of the plaintiff exists in the suit land. At that time, lordship, a house has been already existed in the suit land. And in their counterclaim also, lordship, they have mentioned that only symbolic possession was given, lordship. There's a difference, lordship, you given the possession and the symbolic possession. Because at that time, a house was also there in the suit land, lordship. Therefore, only a symbolic possession was given. That means that, lordship, I have been in possession of the suit land. It's long back, lordship. Is that? There is in the judgment, lordship. Judgment of the trial court.
That is in the judgment where
Judgment in the
court
judgment,
says that perhaps.
Perhaps. As far as the exhibit, lordship. So if
Exhibit G and Exhibit H. Exhibit G and Exhibit H, whereby the possession of my possession has been declared. And there was a direction also that without due following process of law, I should not be evicted from the suit land. That was the finding, and that was affirmed by the sessions board.
lordship may kindly peruse their counterclaim also. Counterclaim of the defendant against my suit.
H.
That is in the LCR lordship.
Counterclaim. What does it?
Yes, here.
13. 13.
Yes.
Page 13.
May I read it also? That the plaintiff opposite party, the defendant counterclaim made an agreement on 5/6
In the counterclaim, this we have read, they have admitted that you have given them possession and thereafter they collected bricks, gravels, construction
Yes, also.
materials.
And in the counterclaim, they have stated the list of payment lordship. When they have given to all the payments, there are two. That the plaintiffs again received 10,000 from the defendant's counterclaim on 2689 by himself, and rest received through his agents as shown below. 1. Rafiqul Islam, son lordship. This is important. 23,689, 1,000. Rafiqul Islam, son on 17,889, 600. Kamsul Haq, brother, 22,1189 rupees, 1,500 lordship. If there has been a full consideration has been payment lordship, there is no evidence lordship. And whether they are authorized to receive the amount from the plaintiff, there is a question lordship. because they have not given the entire money to me, Lordship. Some of them to my son, and one payment has been made to the brother, whether they are authorized to receive the amount, Lordship, whether there is an evidence in this regard. It is a mere statement, Lordship, that the entire amount has been paid.
Yes.
And regarding the counterclaim, Lordship, the counterclaim is also barred by limitation. Why it is barred by limitation? As far as the Limitation Act, 3 years limitation period is prescribed for filing a suit for specific performance. It says there is no date is fixed when the refusal is made, Lordship. In this case, in their WS or in the counterclaim, no specific averment has been made regarding the date of refusal, Lordship. When the plaintiff refused to perform their duty or execute the sale bid, there is no averment, Lordship. A specific date has to be mentioned. And regarding the cause of action, Lordship may kindly peruse para 5 of the counterclaim. That the registry of the sale lead in 89 was suspended by the government for Hati Singmari village. The plaintiff, opposite party, and the defendant's counterclaimant approached the Revenue Settlement Authority for mutation for the suit land. The plaintiff, opposite party, gave consent to the land record in favor of the defendant counterclaimant. Accordingly, the same name of defendant counterclaim number 2 mutated on 3/12/1992, and also agreed to execute the registered sale deed when government given permission that the mutation of the event number 2 was made in the consent knowledge of the plaintiff. That is not true. I have denied that in my written statement against the counterclaim, Lordship. That no consent has been given in this regarding the mutation order. Next paragraph, that the plaintiff opposite later for his illegal gain threatened to dispossess the defendant counterclaimant at the end of 1992. At the end of 1992, Lordship, it has been admitted that the plaintiff has been trying to dispossess them from the suit land. And my suit has been filed on 1998, Lordship, and the counterclaim has been filed on 1999. If there is an illegal trying of disposition, Lordship, they ought to have filed the suit for specific performance contract in the year 1992, Lordship. Under the aforesaid position, Lordship.
Just a moment. Yes.
Even under the aforesaid position.
You were at paragraph 5, referring to invitation.
Yes, sir. Paragraph 6, Lordship, from the company. The plaintiff or his party, later for his illegal gain, threatened to dispose of the defendant's counterclaiming at the end of 1992. The defendant's claimant was compelled to file application for starting a proceeding against the plaintiff, opposite party, and the proceeding by number 1/93 under section 145 was decided in favor of the defendant counterclaim. It has been admitted by them Lordship from the year 1992. The plaintiff tried to dispose them from the suit land. If there's the position Lordship, they ought to have filed the suit for specific performance contract in the year 1992, and they have filed the counterclaim on 1999. Therefore, they clearly barred by limitation, their specific counterclaim.
Yes.
And regarding observation of the learned first appellate court Lordship, kindly table the judgment of the first appellate court. Page number 1. Page 51 Lordship. As stated here and above, I'd like to point out only a paragraph Lordship for the first appellate court judgment.
51.
51. As stated here and above, the paragraph starts from. Lordship, may I read it? As stated here and above, the counterclaim also includes for permanent injunction that the entire counterclaim cannot be said to be barred under Article 54 of the Limitation Act. And in such case, I am of the opinion that the suit also come within the Article 113 of the Limitation Act, since a suit for injunction would be governed by Residuary Article 113 of the Limitation Act, and the cause of action of the state relief arises when the right to sue accused. The plaintiff instituted the suit for declaration of right, title, and possession on 15/5/1998. The suit of the plaintiff itself is a challenge to the alleged position of the defendant. Hence, the right to sue for a defendant in the strict sense accrued lastly on receipt of the summons in the suit. The proposition of law is that if a person obtaining possession of the property in part performance of an agreement of sale can defend his position in a suit for recovery of possession filed by the using section 53A of the National Property Act as a seal. Even if the suit counterclaim for specific performance of agreement of sale has become barred by limitation, the suit filed on 15/5/98 and the counterclaim of the injunction, etc., was filed by the defendant on 1/2/1999. Therefore, the counterclaim is within the period of limitation. These observations of the learned first appellate court is right to be required to be interpreted, because in the one sense, Lordship, first appellate court held that the counterclaim is barred by limitation. Yeah, because I cannot claim the specific performance contract. It is beyond the period of limitation. And in the same time, first appellate court held that our counterclaim is within the time of limitation. Since one part, specific performance contract, has already been declared that it is barred by limitation, there is subsequent relief, permanent injunction, this does not lie Lordship.
Right, there can be a view when, because the court has given a finding to the effect that the counterclaim is the
right to survive because of the receipt of summons. Yes, sir. This is that we show. He has not challenged, and for the recovery of position, they ought to have filed a suit under section 6 of the specific remit act. A separate suit is required. That has not been done. It can't be a multiplicity of suits. In one suit, Lordship, theoretically is incorrect. And as pointed out by my learned friend, Lordship, that I have, there's a cloud on my right title interest. That has been admitted by the defendant also. That I am the rightful owner. There is no question of Lordship, any doubt that I am not the owner of the good land. I am the owner. I have been possessing the good land since beginning. Although it is admitted that there is an agreement, Lordship, that has been cancelled, Lordship, in failure to perform their duty. And whether or I is bound to execute the sale deed from 1989 to 1999, whether they have done something, Lordship, to perform their duty or to execute. There is a long gap, Lordship. No attempt was made on their part to execute the sale deed from 89 to 1999. When I have filed the suit, they have made a counterclaim for a specific performance contract. Under the opposite position, Lordship, their prayer for specific performance contract is failed, Lordship. Their prayer for specific performance contract is barred by limitation, Lordship. It is beyond the time of limitation. And the learned first appellate court has rightly held that I have successfully proved my right title interest, and their counterclaim in respect of the specific performance contract is barred by limit. And therefore the appeal is deserved to be dismissed. This is my humble submission.
On the short reply, my lord, regarding finding that the counterclaim is not barred by limitation, he has not filed any cross appeal or anything. He has not challenged. And regarding title, my lord, it has already I have submitted that since there is no clause in the title, so suit is not mentioned.
This is what finding?
My lord, finding is that the appellate court that the counterclaim is not barred by limitation. Therefore, the counterclaim is within the period of limitation. This finding, my lord, in the appellate court, and he has not filed any cross appeal or anything, my lord. This, and this only because the counterclaim was dismissed by exercising discretionary power. Their discretion has not been correctly appreciated. And regarding time which has mentioned in the plain, in the agreement, there is no mention. In agreement, exhibit A, there is no mention.
Sufficient. The appellants are the defendants in TS 111 of the 1998, instituted before the Court of Civil Judge within bracket Junior Division, bracket case number 1, at 2B. The original respondent number 1 was the plaintiff in the said suit. That on his death. No. We are the plaintiff. No, I have to find. There are two defendants. The RSA 16, yeah, two defendants, number 1 and defendant number 2. Two defendants, that's what I said. Oh, and in the suit, what you call TS 111, yeah. The plaintiff is Mozambique Hawk. Mozambique. Plaintiff is. Since this is no. It's okay, we are writing like that. For the original respondent number 1 was the plaintiff, and on his death, the respondent number 1 is substituted by his legal heirs, the respondent number 1, A to 1E, to RSA 16. The plaintiff, now the plaintiffs have entered into an agreement with the defendant number 1 for in the middle part of Bengali year 1929, they were agreeing to sell a plot of land on receipt of an advance of rupees 10,000, settling the total sale consideration at rupees 23,000 to be paid within 3 months of the date of the agreement. And thereupon, after execution of the sale deed, Gauhati position was be handed over in respect of Schedule the land described in Schedule B. Case of the plaintiff is that as the balance payment was not made despite stipulated demands within the stipulated and extended time, agreement for sale was rescinded, and consequently no sale deed was executed and permission was not delivered. It's projected that in the year 1991, due to river erosion, plaintiff had shifted his homestead to the land and started deciding there by constructing houses, by growing plantation and cultivating the land. Projected that the defendant number one conspired with the land revenue staff and secretly got the land mutated in the name of defendant number two on 3/12/1992. Thereafter filed a petition under section 107 CRPC, alleging attempt to dispossess the defendant from the suit land. Currently, on the basis of police report on 21/12/1992, posting under section 145 CRPC was also executed. It was disposed of by order dated 31/7/1982. Delegating parties to seek relief in civil suit. The available funds by the defendant number one, the joint section judge, an order to the 13th and 1907. No problem. Demanded the matter back to the Court of the United States by an order passing CM number 16, within bracket 3, bracket 2, 96. For the release after a fifth hearing. Learned executive may, the executive may an order dated 13/10/1997 declared position of the defendant number one over the suit land. Directed position
be delivered to the defendant number one. Operation of discharge order was paid. By the one game. Something is wrong.
Additional session, just
Additional section.
state the matter, then thereafter final order.
Case number, what is the case number?
Case number, additional session, criminal revision 11, bracket 4.
Criminal revision, yes. Because here in page 7, it is written as CN. That's why I was unable to accept that.
Criminal revision
Criminal
11,
revision
bracket
number
4, 1997
Page 11 within bracket 4
of 1997.
of 1997.
And judgment was delivered on 5/6/1998.
Final order.
Final order. Exhibit H.
Exhibit H.
H.
Exhibit H does
H.
not.
H.
Order dated
Order dated 5/6/1998.
5/6/1998.
Yes, dismiss the revision. Revision is therefore rejected. Affirm the order of the learned executive.
Thereafter, the plaintiff filed objection against mutation case number 3 of 1993. And thereafter, by an order dated 30/12/1993, the name of the plaintiff and the pro forma defendants were mutated. And consequently, the name of defendant number 2 was struck off. Accordingly, obtaining an apprehension of disposition by stating that the cause of action of the suit arose on 3/12/1996, 21/12/1996, 31/7/1996, 13/10/1997. The plaintiffs had filed yes number 111 of the 1998. The here for a decree declaring that the plaintiff has existing right of title and continuous possession over the land of Schedule B, semicolon, B, a decree declaring that order dated 13/10/1997 passed in miss case number 1 of 1993 is erroneous and not proportionate in law, unexecutable, and is unable to supersede the decree of civil court, semicolon. C, a decree for perpetual injunction restraining the defendant, agents, and held from taking possession from and from entering into the suit land of Schedule B, any part of Schedule A,
semicolon. And we will get a key, decrease for cost, put another. Submissions of the has both on top for the applicant. Number one, number two. It is urged that if that as the plaintiff did not make any prayer in the suit for cancellation of the agreement for sale, the suit would be hit by proviso to section 54 of the Specific Relief Act, which bars any declaration where the plaintiff, being able to seek further relief than a mere declaration of title, omits to do so. And accordingly, it is submitted that the suit of the plaintiff would not be maintainable. In respect of issue number 2, as decided by the learned trial court, submitted that this decision on issue number 6 is not correct. That the by approach of time, the agreement for sale by Exhibit A had lost its force, and therefore, and thereby holding that the plaintiff cannot be held legally bound by contract right Exhibit A. It's submitted that if the position is concerned by a memorandum made by the police, the pursuant to orders passed by the executive magistrate, the police had handed over the possession of the suit land to the defendant on 2/9/1998. And therefore, the order of the appellate court to the effect that the possession on 2/9/1998 was triply incorrect. In respect of counterclaim, while it was held by the learned first appellate court that the counterclaim was within time, but it exercised discretion not to grant any relief to the appellant. Moreover, it submitted that not granting relief, the appellant has the dependence of the learned first appellate court did not consider the fact that as claimed by the defendants, the entire consideration money was already paid. Next. It was next paragraph for 6.5. As the plaintiff did not make any prayer for cancellation of the agreement for say, suit was not maintainable. So this has already come. This has already come. Like, correct. The defendants had admitted the ownership and title of the plaintiff. So, however, as the plaintiff filed a suit seeking declaration of right title and interest, the plaintiffs had clouded his own title. Next part is also submit that the defendant had this is exhibit H by the defendants or plaintiff. Remember, exhibit H was by plaintiff or defendant. 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 The defendant by exhibit H had exhibited the order dated 5/6/1998, by which the criminal revision number 11 within bracket 4/1997 was dismissed. Thereby, the order passed by the learned executive magistrate was affirmed. Exhibit G. Exhibit G. H. That H and Exhibit G is the order passed by the magistrate. So that we have not referred. It is it is next one is further submitted that against the finding of the counterclaim that save is barred by limitation, the plaintiff has not filed any proper objection, and therefore this finding by the first appellate court has attained final. Third contract for the 11 counsel for the respondent has submitted that as possession of the land was given to the plaintiff by the orders passed by the executive magistrate by the exhibit G. The right, title, and interest of the plaintiff was clouded, and therefore suit was filed, it was maintainable. My lord, may I take the MCR, my lord, because in the decree part, this GH, all this proof and not mentioned. It's not there. Not mentioned. That is why we are asking you. That's why, in the meantime, I had, stopped and I was writing. I, I was making the list of exhibits.
It has mentioned only exhibit 1, 2, 3, 5.
But
and
you look at this record, it is
Yes.
essential because what I find is,
Because in my records, all these things are mentioned instead of scoping. That is why I want to check.
you want exhibit C1 file
It is in judgment, it is mentioned exhibit C.
in the judgment.
Yes.
Okay, it will look. It will-
Okay. It is there.
Hmm?
Yes, it is there.
It is there. Just fact it is.
Flex, it is there now. But in the judgment, these things are not mentioned.
But
The last part.
that's why I did not find it, that's why I was writing. But it was not complete.
Yes.
Paragraph, the paragraph 2 and 3 of the claim might have been submitted that it is a specific case of the defendant that the agreement was rescinded. And therefore, there is no requirement to seek any declaratory relief in the suit. Insofar as the agreement is concerned. So as to seek cancellation of the sale, deed of agreement for sale. So it's agreement for sale. Yes. By referring to statement pending charge of 9 and 10 of the statement, it has been submitted that the defendants had stated that there was no condition required for sale to be awarded within 3 months.
One thing, my lord, regarding the state that the son was not, that letter is also there, issued by the plaintiff, authorizing his son to collect the money.
That is actually set an exhibited document.
Yes, exhibit B.
Exhibit E.
B1.
B1 is the signature, B is the. Then next exhibit C also there.
Just write it down, the piece of paper.
Yes.
I will give.
Flegma. Oh.
This was taken to the effect that the balance amount of money was paid and therefore position was given to the defendant.
And it is the unborrowed.
And moreover, in paragraph 12 and 12 of the written statement, from reference is made to proceedings of MC1 of the 93 and CR 11 within bracket 4 of the 1997, which was multiple proceedings against the plaintiff. And therefore, the plaintiff had to approach the court by filing its suit. That's all. It submitted that to the defendants take a plea that balance amount was paid. But there's no evidence as to how the money was paid. And moreover, there's no proof of showing authorization to particular and some to receive money on behalf of the petitioner. Oh, sorry, plaintiff. submitted that in the written statement and the counterclaim, defendants had not pleaded the date of refusal by the plaintiff to register the sale deed. And therefore, dismissed, the criminal proceedings was launched way back in 1993, filed in the year 1999, with the obviously part by litigation. Authorizing. There is that. Paragraph 5, the statement of fee is taken that the registration of sale deed was honored in the year 1989. Therefore, the illegal mutation carried out on 3/12/1992 gave a authorization for the plaintiff to file the suit. Next, referring to statements made in paragraph 18 of page, in paragraph 6 of this statement, it's submitted that as the defendants admit that in 1992 the plaintiff tried to evict them. The counterclaim to be part by limitation as it can be presumed that the was requisite part of the defendant to, sorry, plaintiff to register the sale deed. Submitted that if the finding to the effect that the suit is barred by limitation is correct, that there cannot be a cause of action for a counterclaim from the date of receipt of summons. Therefore, the appellate, therefore it is a the appellate was not appellate judgment was sustained. So that the specific relief, the prayer for specific relief is barred by limitation. These are the submissions I have concluded and reserved judgment. But there is question also for the appellant in RSA 16 of 2010. Oh, you are appellant in both the cases. You are appellant in both the cases.
Both because appeal filed by both.
Both the appellants in both the appeal. Also have Mr. P. Karita and also for the submissions are concluded. This is one of the oldest cases. Sir, this 16 is against what? Well, RSA 16 is against what?
RSA 16
Against counterclaim. Against counterclaim.
Against 15. Yes, no, RSA 16 of 2010 is by the
another 10,000
The defendant's appellant is
10,000 টাকা লিখে on
against the
26
dismissal of the counterclaim
on 26/59
and RSS 17 of 2010 is an appeal by the appellate that defendant against the
Another
for decreeing the plaintiff's for
10,000
decreeing the plaintiff's
for against the decree
10,000.
cast in the suit of the plaintiff.
out of 13,000. And look, I have marked exhibit B also, remaining balance amount out of 13, 10,000 was received. And in hand of the exhibit 2, B, the amount was carried out, the letter has been given by the defendant plaintiff to the defendant number 1, and that to accept the balance amount.
all those documents were not in my record book. That's why I have submitted it. Those documents are not in part of my brief note. Okay.
Actually, in this case, my lord, neither me nor from their side, any
There is no communication.
communication. Only communication is till appellant number 1 was alive, there was a communication. No, there are other oldest cases. Also. No, I have given a list near about 25 cases. 25 from my side, old case 25. 9, 10, 11, 12. 9 and 10, I have given some list.
Obliged.